Good morning, this is your Kelso Report for Thursday, June 7th, and I'm your host, Clark Kelso. We begin with a Ninth Circuit decision arising in the area of education law. In M.M. versus Lafayette School District, an administrative law judge dismissed several of a special education student's claims against Lafayette School District prior to holding a due process hearing, because the claims alleged conduct outside the Individuals with Disabilities Education Act's 2-year statute of limitations. The child's parents challenged the ALJ's decision by filing an action for judicial review in federal court. The district court dismissed the parents' complaint against Lafayette, finding that they were not yet aggrieved parties within the meaning of the IDEA, because the ALJ had not yet issued its final decision. The parents appealed, contending that the IDEA does not require a defendant to wait until a final decision has been issued before seeking judicial review challenging pre-hearing rulings, essentially interlocutory appeal. Well, the Ninth Circuit agreed with the district court. The applicable statute, Title 20 U.S.C. Section 1514, provides for judicial review of the ALJ's, quote, findings and decisions, close quote, made in the due process hearing. And this language clearly is referring to the final decision, not to pre-hearing rulings. That way we avoid having interlocutory appeals in these sort of administrative hearings. It's essentially a final judgment rule. Next, a constitutional law case involving the First Amendment. In Kahumanu versus Hawaii, the Ninth Circuit considered the constitutionality of permit requirements for holding commercial weddings on state beaches in Hawaii. Now, assuming that the state beaches are traditional public forums, the clear rule is that reasonable time, place, and manner restrictions on speech are permissible if they are justified without reference to the content of the regulated speech, they're narrowly tailored to serve a significant governmental interest, and leave open ample alternative channels for communication of the information. The Ninth Circuit agreed with the district court that the general permitting requirements were reasonable time, place, and manner restrictions intended to minimize conflicting uses of limited beach areas. The Ninth Circuit did strike down one portion of the permitting regulations that purported to give the chairperson of the Department of Land and Natural Resources unilateral power and absolute discretion to revoke or modify a permit at any time. For the court, this unbridled discretion created too severe a risk that non-viewpoint neutral decisions would be made regarding permits that, in the absence of any substantive standards, would essentially escape any type of meaningful judicial review. Next, we have a certified question from the Ninth Circuit to the California Supreme Court, also First Amendment. Civil Code Section 2527, California law, requires drug claims processors to generate studies about pharmacy pricing, summarize the results, and then disseminate the information to their clients. 3 intermediate California appellate courts and 2 state trial courts that have addressed the issue have held that these reporting requirements violate the free speech clause of the California Constitution. Notwithstanding these cases, a 3-judge panel of the Ninth Circuit concluded that the California Supreme Court would interpret its free speech clause by relying on federal judicial interpretations of the First Amendment, and conclude that the statute is constitutional under the First Amendment. Well, the Ninth Circuit took the case in bank and then certified to the California Supreme Court the question of whether Civil Code Section 2527 is constitutional. This is a good case for the use of the certified question procedure, since it will result in state and federal courts agreeing upon an important question of constitutional law. Hopefully, the California Supreme Court will take the certification and will get a clear answer to the question. Next, we have a case involving enforcement of judgments and collection of judgments. As part of its efforts to collect a $3 million judgment, the plaintiff in Source Corp versus Schill sought a turnover order, directing the defendant to turn over $125,000 in cash that was held in a safe at the defendant's residence to the El Dorado County Sheriff. The defendant argued that the cash was earnings that were exempt from levy by virtue of CCP section 704.070, because at the time the cash was earned, there was already a garnishment order in place, and this cash was what remained after the garnishment. The 3rd District disagreed. Section 704.070 limits its protections to, quote, earnings that were paid to the employee during the 30-day period ending on the date of the levy, close quote. And the 3rd District interpreted this language as meaning that any earnings which remain in the account after the 30-day period has passed are subject to levy. As the court explained, the purpose of section 704.070 was simply to make sure that the debtor had enough earnings for the basic necessities of life. Well, given that purpose, there's no reason to extend the protections against levy to earnings that were held for more than 30 days, since apparently the debtor has enough cash on hand to make it through the month with quite a bit left over. Next, search and seizure. The defendant in People v. Laszlo was placed on probation following her guilty plea to 1 count of burglary and 1 count of possession of methamphetamine for sale. That probation was revoked after her subsequent arrest on new criminal charges. The evidence supporting that new arrest was suppressed after a hearing under section 1538.5, and the new charges were dismissed. But that evidence was nevertheless used as a basis for revoking probation. The defendant argued that the order reinstating and modifying the terms of her probation must be reversed because section 1538.5, subdivision D, prohibits reliance on previously suppressed evidence at all hearings. Well, the 1st District easily rejected this argument, since Proposition 8, the Victims' Bill of Rights, not the recent Prop 8, but the Victims' Bill of Rights enacted in 1982, abrogated the broad exclusionary rule that's in subdivision D of section 1538.5 of the Penal Code, except to the extent required by federal constitutional law. Well, the exclusionary rule under federal law does not apply to parole revocation hearings, and so the 1st District held the evidence need not be excluded from the defendant's probation revocation hearing. And that's it for today's Kelso Report. Have a great day in the law.